To the order.
There we go.
Thank you. It's item, oh, it's a 248, item 15. Yeah, please, Ben.
Thank you, Dr. Matecki. We have, as discussed earlier, moved item 15 from tomorrow to today, and this will be the item we'll cover now. We are going to be reviewing the most recent direction from the board to make changes to the disciplinary guidelines and uniform standards. And what we have before you today is the memo capturing the new information, as well as including some of the SACC, so the Substance Abuse Coordination Committee information, to bring ours in alignment. And we can go through each of the changes. Just for clarity, to show people, the first item for item 15, it's 11 on the tab, is the memo. Then we have the language with the highlighted portion showing what we're changing now. After that, we have the clean language as if we were changing the document from the very beginning, not all the iterations. So the first one is the changes from the last meeting. The next language page is any changes from from our current disciplinary guidelines. And then after that, we have a 72-page document that shows all of the changes with strike-throughs and underlines, as well as comments addressing where some changes have been requested by the board or comments to look into further details. And after that 72-page document, we have a clean copy, again, just like the language, where it's changes from the original document. Christine?
This is a large document to get through, and I'll try not to read verbatim from the memo, but given the fact that we have a few new board members, I did want to give a little bit of history. This has been a regulation that we've been trying to get through for a while. I think we've seen different iterations of it since 2012. And at the last board meeting in October, it was, I think, the first time that we brought the document combined. Previously, it had been brought to the board as separately as changes to our disciplinary guidelines, and then implementation of the uniform standards related to substance abusing licensees. At the last board meeting, we combined it, and there were several changes. And just going back a little bit further, so I think you guys heard about the SAC committee, which is all of the healing arts executive officers. In 2011, they did implement all 16 uniform standards and develop the language for that. And then it's on each individual board to promulgate the regulations to implement all of those standards that apply to substance abusing licensees. And again, we also have dated disciplinary guidelines that date back to 1996. And so enforcement uses those guidelines, as well as administrative law judges, deputy attorney generals like John Gatchett, who you saw here today. So, and the board, yourself, you use those guidelines as well in making decisions for licensees and applicants. So when they're dated, we need to get better language, better guidance. So that's real important. And then also just implementation of these uniform standards. We have, as Ben said, we have the text here today. And one large change that you'll see here today is previously we have brought text that establishes a substance abusing licensee through a hearing. And now we're proposing actually a different direction, and I'm going to probably read from the memo, just letting you know that there's actually three different options that healing arts boards and bureaus are putting forward in defining what is a substance abusing licensee. So we did conduct some research into those 20 healing arts boards and bureaus. And of the three options, let me describe those. Option one creates a rebuttable presumption that the licensee is a substance abusing licensee. Once grounds are established that involve drugs or alcohol, the licensee is considered to be a substance abuser unless evidence rebuts that presumption. And then option two allows for a determination to be made after a clinical diagnostic evaluation that the licensee is a substance abusing licensee. And option three, which is what we previously had brought to the board, requires the board to prove at hearing that the licensee is a substance abuser. So after research, we found that 9 boards have implemented the uniform standards through rulemaking, and of the 9, only 1 board used option 3, which is what we were previously proposing. 3 boards used option number 2, and 5 boards used option number 1. Staff has also favored option number 1 and chose to propose implementation of option number 1 and bring that to the board today, which would create a presumption that the licensee is a substance abusing licensee, which in turn gives them notice that they have the burden of rebutting that presumption. This option also aligns with what seems to be the majority of other boards and their favored option. We rejected option number 2 because it relies on a clinical diagnostic evaluation, which may create a lack of clarity and possibly be problematic for an ALJ when faced with a violation that involves drugs and or alcohol when sufficient rehabilitation has been provided by the licensee. And option 3 was rejected due to the obligation of the board having to prove that a licensee is a substance abuser, which may be difficult to prove. So that's what we brought here today, and I'll go ahead and we can go to attachment A, or the first attachment where it's the text. So what you'll see in yellow is the new text that we're bringing today, and what you see that's underlined and crossed out was what we previously had brought. And that had read, if after notice and hearing conducted in accordance with Chapter 5, Part 1, Division 3, Title 2 of the Government Code, the Acupuncture Board finds that the evidence establishes that an individual is a substance abusing licensee, then the terms and conditions implying the uniform standards related to substance abusing licensees shall be used in any probationary order of the Acupuncture Board affecting that licensee, in addition to any and all other relevant terms and conditions contained in the Acupuncture Board's guidelines referenced in subsection A. So now we're proposing, if you go back a page, for subsection B to read, if the conduct found to be grounds for discipline involves drugs and or alcohol, the licensee shall be presumed to be a substance abusing licensee for purposes of section 315 of the code. If the licensee does not rebut that presumption, in addition to any and all other relevant terms and conditions contained in the disciplinary guidelines and uniform standards related to substance abusing licensees, the terms and conditions that incorporate the uniform standards related to substance abusing licensees shall apply as written and be used in the order placing the license on probation. Again, we feel that this is clear. It puts the burden of proof on the licensee, and it makes it a little more uniform in that if we're seeing that a case involves drugs and or alcohol, we're going to make that presumption that they are a substance abusing licensee, and it's on them to rebut that. And that's why we're bringing this language here today. And so the other changes you guys have already reviewed. And I don't know if you guys have any questions.
Yeah, I'd like to add
Oh,
to that.
yeah.
Hopefully I make it through this one. So thank you, Christine. Christine did a lot of work researching what the other healing arts boards are doing in order to present these three options to you. So I just want to emphasize, the first option creates a rebuttable presumption, and the so that does occur at the hearing. And what that would say is that if there is a violation involving drugs or alcohol, it's presumed that the licensee is substance abusing. And then the burden shifts onto the licensee or applicant to show rehabilitation and that, or to rebut that they're not substance abusing. One reason for this option, I think that why some boards have adopted this version, is that the licensee is often in the best position to offer information about their own rehabilitation, as opposed to, for example, the AG's office, who may not have information about, what courses the licensee has done or just why they're rehabilitated or how long they've been sober or, just all of that information. So option one presumes that the licensee is best positioned to provide that information, and so it does that. Option number two kind of punts the question of whether or not a licensee is substance abusing onto the clinical diagnostic evaluation. Clinical diagnostic evaluation is the first uniform standard. So it just kind of says, well, I think, for example, one board who has done that is the physical therapy board. And I think one reason they adopted this version is they said, well, the board didn't necessarily feel comfortable making those decisions about who's a substance abusing licensee. But in the same token, I think it has created some difficulties because sometimes it is kind of clear to the board whether or not someone's a substance abusing licensee. So for example, if they had one DUI, 10 years ago, there haven't been any further incidences, as an example, the board may in some situations feel comfortable finding that they're not a substance abusing licensee. And the challenge with number two is that in every instance where there's alcohol, it would go to a CDE, and that can be expensive. And sometimes the board may ultimately feel that's not necessary, but that might tie the board's hands, in other words, for option number two. And also with option number one, the board can always apply the uniform standards even if they find rehabilitation. So the board can say, okay, it's an alcohol abuse situation or alcohol drug use situation. Burden shifts to the licensee to show rehabilitation or that they're not a user. And then the board can say, we feel that, you're not substance abusing, but we, want to, for purposes of public safety, we still think it's important to have certain checks just in case. Because maybe we're not 100%, sure, and we want to have some certain checks in place. The board is not prevented from then picking and choosing which uniform standards they want to apply in this situation, like fluid testing or some of the other ones. So whereas if you find someone is substance abusing, then all the uniform standards have to apply, with certain of them still being discretionary, but it's kind of more restrictive once you find someone substance abusing. I know, for example, I've talked to psychology board who does option one, and I didn't have any sense that they've had any issues with how that one works, where I have gotten a sense that option two sometimes can be difficult. And option number three just keeps that burden on the AG's office. So it's on the AG's office to kind of delve into whether the person's substance abusing as opposed to the rebuttable presumption. And this one might be problematic for the inverse reason that option one is good. Option one puts it on the licensee to show the rehabilitation, whereas option three kind of keeps that burden on the AG's office, and they may not be the best positioned to do that because they don't have all of the information about whether or not someone's rehabilitated or so that's kind of the difference between the three options. The text that Christine has here for you highlighted is that option one text because I think that is staff's favored approach.
That is correct. In reviewing these three options and the board outcomes, we did determine that option one is favorable.
Yeah, and I think that what's interesting about the board's current text is it doesn't really identify how how it is established that someone's a substance abusing licensee. It just says that if the board finds that the evidence establishes they're a substance abusing licensee. It doesn't indicate whose burden it is. It doesn't, so it is kind of vague on that point. So for the board, adopting any of the options 1 through 3 would, I think, add more clarity than what currently exists in the board's text. And to keep in mind, the reason I think boards have different ways of going about this, why there have been these 3 routes, is that the Business and Professions Code 315, which sets forth the uniform standards, I think pretty much all it says is that, a board shall find whether someone's a substance abusing licensee. And if they are, the uniform standards shall apply, but it doesn't define what a substance abusing licensee is or how it should be established. So I think in that way, the boards have had kind of discretion to choose their approach on how to determine that, and hence these 3 options or models of doing it have evolved or emerged. Yeah, thank you. So with that.
Yeah, thanks for adding.
Yeah, I think that now it's, what we're presenting to the board are these 3 options for discussion and selection. And if the board does want to go with option 1, we have that text there.
Any questions or comments from the board members at this point?
Okay, I don't know if I should move on, or, it's here for, if the board chooses to take a motion, but I can also move on to the actual document that's incorporated by reference and some of the changes that have been, or that we've proposed here today. So I can move on if there's no questions on the actual text.
Sure.
Okay.
Yeah.
So, going past the clean copy of the text, you'll come to the disciplinary guidelines. And so anything that's highlighted in yellow, as well as underlined, that would be anything that we added since the last October board meeting. So I don't want to go through everything else, since you guys have already reviewed it. So I'm going to just follow along with the memo, because the memo is just calling out those highlights, basically. So going to page 4 on the introduction. Let's see. So the description for the 3rd condition type, which is special conditions, which is our conditions that apply the uniform standards, it was modified to remove reference to the previous text of 1399.469 and was replaced with this new proposed rebuttable presumption language. The board also requested that the direction regarding the sex offender registrants be moved to another more appropriate location of the disciplinary guidelines. So we did move that section under the terms and conditions part of the DGs under Business and Professions Code Section 4955B, which is a substantially related conviction. Staff indicates that this part of the DGs is more relevant because this section involves licensees who are sex offenders who are subject to discipline under BPC 4955B for having sustained a substantially related conviction. Does anybody have any questions on that section? Okay, so moving on. Page 6, this section, general considerations, we went ahead and moved this to a more appropriate place, and you'll see that later on, thinking that the placement would provide greater clarity to the reader. Page 7, to the terms and conditions, the board requested that this section be restored. Additionally, language was modified to remove reference to the previous text of 1399.469 when explaining when special conditions will apply, and it was replaced with the new rebuttable presumption language. Any questions? Okay. And page 8, just some some changes to that, and we'll get into the conditions later on that have been changed or edited and proposed. And then we just kind of reformatted the list here for ease of reading. I did notice, I think it was an error on page 9 of our existing language in the disciplinary guidelines. It did say proposed decisions, but it's on a section about stipulated settlements, so I'm thinking that's correct there. So, and then moving on to page 12. So this is where the general considerations was moved to. And this is the beginning of where we sort of have sections laid out with regards to mitigating evidence to consider, any kind of rehabilitation criteria to consider. So this would start that. So the board did request that we review this section as well as evidence of mitigation and evidence of aggravation sections to see if any of the sections could be consolidated. And after we reviewed those, 4 of the 13 general factors to consider were removed or edited. And those four factors were already actually included in the evidence of aggravation and criteria of rehab sections. So that's what you see there, just so there's not redundancy. And then page 13, this is reflecting option 1 that you guys went with today in regards to AB 2138, substantial relationship criteria. So this would match that. We're not using the actual citation of the section number, but wanting to incorporate that criteria into the disciplinary guidelines so it's all in one document for ease of reading and having it readily available to the ALJ, to the DAG and enforcement staff, board members. So it's language you guys have already seen. Page 14 through 16. So again, this is mirroring the language that you guys just saw for AB 2138 with the criteria of rehabilitation. Previously, we proposed a section that was titled Demonstration of Rehabilitation, and we didn't want there to be redundancy again, so some of that was removed and replaced with the criteria that will be implemented through regulation. So we have it delineated by A, the denials criteria of rehabilitation, and B, the criteria of rehabilitation for suspensions and revocations. And then going on to page 16, what you see in pink, which is, I actually have like comments here. This whole section was originally part of this section, but it seemed more applicable to the reinstatement and penalty relief hearing section, so it just got moved there, so you'll see that later on. And okay, and then we moved to the reinstatement penalty relief hearing section to this location of the document, because again, it kind of goes in line with our other general considerations and rehabilitation criteria. And this is criteria that was already in place in our 1996 guidelines. Except for on page 19, there are some additions here and considerations, which you guys have already reviewed in the past. So the board had asked us to, review these sections along with the general considerations to be sure there wasn't any duplication. We felt that both sections should remain because we feel that it differs from actual criteria of rehabilitation or the general considerations because it's actual examples that the board can consider. when a licensee is presenting evidence of mitigation, these are some examples here that, that you would consider. Again, also some evidence of aggravation that would be considered that would then drive the penalty up. So we felt that it was different and just more information for the ALJ, for the board to consider. And so, yeah, page 23, that's where the reinstatement penalty relief hearings was originally at. We're just showing that it's been removed and moved up. And page 25, just an update of our standard terms and conditions. And going to the next page, page 26, this was a condition that the board had wanted us to research more, and to see what other boards have as their tolling condition. So we reviewed probation terms from 4 other boards and favored the tolling conditions from the Chiropractic Board of Examiners and the Board of Psychology. So the proposed standard condition has clear language that outlines the circumstance in which a probationer will be told when out of state or in state not practicing, and that was specifically what the board wanted to look at. Not just tolling for someone who went out of state while on probation, but also who's not practicing in state. It defines what constitutes non-practice and solves the problem faced by enforcement when licensees remain in tolled status for years, which we do have. This would be a big change. We do have a good chunk of our probationers who actually don't practice, and so they are just kind of, following along with their probation, but there may be probation conditions in place, like practice monitor or billing monitor, where it just can't be applied, but their probation isn't tolled because the current language only states that out-of-state practice or residents would toll the probation and place it on hold. So this would change that. And also, the proposed condition states that probationers that cannot remain in tolled, or that they cannot remain in tolled status for more than 2 years, otherwise it would constitute a violation of probation when the 2 years is exceeded. Additionally, the proposed condition excludes cost recovery as part of the tolling terms and requires that probationers keep up on their cost recovery even when tolled. Finally, we just changed the titling of the condition and just making it more broad.
Oh,
So I don't know if anybody had any questions on that section, because that was a specific area that the board had wanted us to bring back. If not, I can move on. Okay. Page 29, proposed probation condition number 14, disclosure of probation status. This is a new condition which implements the changes of Senate Bill 1448, which I had covered in the regulatory update. That does go into effect July 1, 2019. And it requires that all probationers provide written disclosure to all patients or their surrogate that they are on probation, and the disclosure must contain the following: respondent's probation status, length of probation, the probation end date, all practice restrictions imposed by the probation order, the board's telephone number, and an explanation of how the patient can find further information on respondent's probation by running a license verification on the board's website. The proposed condition also provides some deadline and logistical requirements that we added in to make it more operational. So this would put us in line with that bill and that new law. And that new law does become effective in our act, the Acupuncture Licensure Act, like I said, July 1 this year. Any questions on that? Okay.
All right.
Okay, so we'll move on. And you'll see throughout the document, it was requested that we spell out and write out the number of days, as well as put them, the number in parentheses. So we made that a uniform global change. So jumping over to page 30, was it 37? Well, it starts on 37, but the actual change is on page 38. Previously, we had the old regulatory language from 1399.469 established at hearing. So we just changed it to the presumption language, just noting that you wouldn't use this term, this probationary term, if you found that the licensee was a substance abusing licensee, and it directs you to use the special terms and conditions to incorporate the uniform standards in lieu of this condition. But we retain this condition, alcohol and drug abuse treatment program, for anybody who maybe does involve drugs and alcohol, but they've rebutted that presumption, and they're not determined to be a substance abusing licensee. And that was a change that we made on this one, as well as the attend chemical dependency support and recovery groups. As you can see there on page 39, as well as on the abstain from drugs and alcohol and submit to tests and samples condition number 29. You'll see on page 40 that we made that same change, that notation. And then moving on, where's the next thing? So we're going to jump to 48. 48, we removed this subheader here just to be consistent with the other terms and conditions sections. Plus, our legal counsel pointed out that it was a little confusing because it did say standard language, but they are
Special terms.
yeah, they're not standard. I mean, it's standard, but you get it confused with the standard terms and conditions. So we made that change, and then the introduction to the special terms and conditions section was modified, and that was again to kind of align with the proposed new rebuttable presumption text that we were bringing here today. Page 51. So Saul kind of touched on this a little bit because these are our special conditions that implement the uniform standards. And she had talked about how some of the uniform standards were determined to be discretionary. So we wanted to call that out and make a note of that, which we hadn't done in the past. So like the clinical diagnostic evaluation, it is discretionary to order it, but if it is ordered, the cease practice order is mandatory, which is also within this special condition, clinical diagnostic evaluation and reports. And then whether a treatment program is ordered is also discretionary, which is covered in this term. I jumped over one spot of page 50. If you see my comments here, we were proposing to take out these two strike-through sections. It had originally barred the board from considering a clinical diagnostic evaluation that was conducted prior to a decision being effective. But we feel that that's not necessary. That's not what the uniform standards was implementing. Plus, if a licensee were to do that, we don't see any issue from accepting the clinical diagnostic evaluation they did, as long as they followed the requirements that we have in place with our probationary condition. And then we also removed a sentence that was now inconsistent with our new tolling term. So, again, on page 51, special condition 36, we do note that the notice of employer or supervisor information, that uniform standard that it's implementing is mandatory. So we make that specification there. And then over to page 54, the note on special condition by 37 biological fluid testing, drug testing standards are mandatory and shall apply to a substance abusing licensee, and the required testing frequency shall be ordered. So that, again, is a mandatory uniform standard. Special condition 38, substance abuse support group meetings. We have a note there that we added. Whether facilitated support group meetings are ordered is discretionary. Under the disciplinary guidelines, non-facilitated support group attendance, such as an optional term that we have in our optional terms and conditions, attend chemical dependency support and recovery groups, could also be ordered. Page 56, we specify that the worksite monitor is discretionary. It was also requested, go to my notes, that, it was requested that Business and Professions Code Section 4935 be added to the recommended action by a violation. That code be added, so we just updated the index of violations. Also shortened the title of 4955A. We just need a reference for the ALJ to refer to, not the whole section. And then we just have some different changes where we were updating the terms and condition numbers. So that's why that's highlighted, because there was additional terms and conditions that we added. And page 66 to 67, you'll see those sections 4935, A1, A2, B, and C have been added. So if a licensee were to be either convicted or been in violation of these sections, then this could be referred to see what kind of administrative penalty to do. And then on page 68, under section 4955B, conviction of a substantially related crime, that's where we, under the note section, that's where we put that sex offender registrant language. It fits more appropriately there. And I believe that sums up all of the changes. And again, there's just a clean copy in the back, or as the last attachment. But this shows all the, versions from the last time, which is kind of nice.
Thank you, Christine. That was very thorough. Are there any questions or comments from the board? Does the board feel we've addressed their direction from the last meeting to their satisfaction?
Yes, nice work.
How would the board like to proceed on this matter? There's sample language for a motion under the memo, or if there's additional changes that the board would like to see incorporated. We have, as Christine noted, provided you with the options that the board did end up selecting for AB 2138, so that's included here.
I'd be in favor of the motion to approve on page 7. I can do that. I'd move to approve the proposed regulatory text for Title 16 CCR Section 1399.469 to amend the title of Division 13.7 of Title 16 CCR to adopt new Article 6.1 of Division 13.7 of Title 16 CCR, to adopt new Article 6.2 of Division 13.7 of Title 16 CCR, direct staff to submit the text to the Director of Consumer Affairs and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing.
Thank you. We have a motion on the table by Member Harabidian. Do we have a second?
I second.
Member Francisco Kim seconds. Any public comment? Seeing none. Ms. Brothers, if you could please take a roll call vote on Member Harabidian's motion.
Dr. Mateki?
Yes.
Chan is absent. Chimino?
Yes.
Harabedian?
Yep. Yes?
Kim?
Yes.
Lee?
Yes.
Osorio is absent. The motion passes 5-0, and that's to, the motion was read to approve the text and the amendments and adoptions of the divisions and articles.
So I would recommend actually a separate motion to approve or adopt the amendments to the disciplinary guidelines themselves.
Okay. Would a member like to make the motion to adopt the amendments themselves?
The motion can basically read like the one that was just read, so approve, and instead of those 4 bullet points, it would be to approve the amendments to, or to adopt the proposed text for the disciplinary guidelines and uniform standards related to substance abusing licensees revised March 2019, which is incorporated by reference into Title 16 CCR Section 1399.469, and direct staff to submit the text to the Director of Consumer Affairs and Business and Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. You don't have to repeat that. If
Someone wants to take that motion?
suggested motion language.
I move. I take the motion.
Dr. Mateki motions. Do we have a second?
Second.
Member Francisco Kim seconds. Public comment. Seeing none. Roll call vote, please.
Dr. Mateki?
Yes.
Chan is absent. Chimino?
Yes.
Harabedian?
Yes.
Kim?
Yes.
Lee?
Yes.
Osorio, also absent. Motion passes 5-0, 2 absent. And this is motion to approve the amendments to the disciplinary guidelines, uniform standards, which is incorporated by reference.
Perfect.
Okay.
I'll give you the language.
Okay.
Thank you, members. This has been a long working document, like Christine said, since 2012. And the board's been seeing it every couple of years and quite often in the last year. So, yeah. Thank you all, staff, members, council. This has been quite the experience.
Thank you. Thank you.
Okay.
So,
We can break and then go for the education committee, or do you want to go straight to the education committee?
so how you members like? You guys want to break, or should we just go? Should we just go to education committee, or you guys want a break?
Yeah, I think I think we can just go forward with it if Jay's ready. I mean, I don't think it's going to be very long, so.
Okay. So
But
we
if other
have a,
members, I mean, members are free to leave, right, that aren't
Yeah.
on the education
and then we
committee,
will
so,
be
yeah.
back. We
But I don't
still
think this is
have
going
a
to take
lot.
very long.
Yeah.
So we still have 2 items. We will continue education committee meeting, and then we will have the item number 10 after the education committee meeting. So the members not on the committees, now we can, okay.
Yeah, members not on the committee are welcome to step down, or we ask that you step down to leave the committee members up here.
So wait, I have a question.
Oh, sorry.
So are there any full board meeting items after the education committee, or is that the last item?
My understanding is that that's the last item, but we can do a double check.
What about the continuing education ethics?
That's what we'll be doing in.
Oh, okay, okay.
Yeah, so we could adjourn the,
Yeah,
yeah, it's a
so
good idea.
I would recommend putting the full board meeting into recess until day 2 of the agenda, and then commencing the education committee meeting.
Okay,
Amy, would you like to do that?
sure.
No, because you have to track that. We're going
Okay.
into recess.
So then we will recess the day 1 of the board meeting.
It's 3:33,
It is 3:33,
and
and we will,
reconvene tomorrow at 9
Reconvene.
a.m.
okay, we will reconvene tomorrow at 9 a.m.
No, the ethics committee will be meeting after this. We're ending the day 1 of board meeting, starting the committee meeting, and reconvening the full board meeting tomorrow. Please.
Yes,
Thank you, Mike.
thank you. So, board members.
We recommend Please. Okay. So we'll take 5 then. For whether we are
And then
legal
eat, right?
reasons, we'll take 5.
Okay.
We'll call the Education Committee meeting to order. It's March 28th, 2019, 3:40 PM.
Okay.
You don't need to, but you can. Doesn't hurt to identify who's on the committee.
I'll go ahead and take roll. Harabedian,
Here?
Kim,
Here. Okay, hello, Education Committee. We're going to start a discussion on the initiation of rulemaking to amend Title 16 California Code of Regulations, Section 1399483 and 1399489, continuing education's ethic requirement. So the issue was to review and discussion of proposed changes to the text of Title 16 CCR 1399483 and 1399489 regarding biannual continuing education requirement of 4 units in law and ethics. The proposed regulation has not been publicly noticed with the Office of Administrative Law. So possible action items for the board is to discuss on amending the text of Title 16 CCR 1399483 and 1399489 to be a bit redundant there. So the history for many years, many years, the Title 16 CCR Section 1399489.2 allowed licensees to take up to 4 units of CEs in practice management and medical ethics to meet their biannual CE requirements for license renewal. However, in December 1999, this regulation was repealed. Historically, the board's laws and regulations have not required licensees to take a minimum of CE laws and ethics. In 2002, due to a continuing education focus group, there was a discussion and a desire to require a minimum number of CE in ethics, continuing education in ethics, at least in the first few years of licensure. Resulting from this focus group and other legislative mandates, in 2008, the board promulgated CE regulations to address legislative, regulations to address inadequacy, but a minimum of continuing education ethics requirement was not implemented. At the November 11th, 2012 board meeting, the board reviewed text for the new CE ethics requirement and delegated further refinement to the Education Committee. The following text was approved in 2012. Now, this text is not what we're going to be looking at today. 1399482, this is a historic suggestion. An acupuncture shall take no less than 4 hours of continuing education in professional ethics every 2 years to meet his or her continuing education requirements. At December 14th, 2016 Education Committee meeting, members reviewed the proposed text and requested additional changes be made by staff and be brought back to the full board for consideration for possible approval. At the October 25th, 2018 board meeting, the board reviewed the proposed text. There was discussion on the issue of whether the ethics requirement was Category 1 or Category 2. The board requested staff research other examples of the ethics requirement and define active and inactive status in the Part C of Title 16 CCR, Section 1399-489, and referred this item for further discussion to the Education Committee. So the discussion. Several other boards have a similar requirement. The Board of Behavioral Science requires 6 hours of laws and ethics every 2 years for all 4 license types that they allow. The Physical Therapy Board of California requires 2 hours of continuing education ethics, laws, and regulations per 2-year renewal cycle. The Chiropractic Board requires 2 hours of CE and ethics per 1-year renewal cycle. The Psychology Board does not have a specific hourly requirement in laws and ethics, but licensees are required to self-certify on their renewal application that they have kept abreast of the changes in law. Staff proposes to place the requirements into Title 16 CCR Sections 1399-483 and 1399-489. The new text contains the following additions and changes. 1399-483E, the inclusion of self-assessment of ethics and law materials as requested by the committee. Placing text in this section, the requirement that all ethics courses, whether online or in person, need to complete a self-assessment test. A self-assessment test would test the understanding of the subject matter. The existing text in the subdivision D only requires tests for courses taken in independent study. There was also renumbering of section 1399-483 subdivision to accommodate the addition of subdivision B as described above. Section 99489A clarifies that all licensees in active status shall complete 50 hours of CE units every 2 years as a condition of renewal. This change requested by the committee helps define the ethics requirement and will be applicable to active licensees only and not to a licensee on inactive status. 1399-489C, this new section creates the requirement of 4 hours of CEUs, continuing education units, in the law and ethics to be taken for every 2-year renewal period. This section also waives the requirement for licensees who are within their initial renewal period, typically 12 to 23 months, or on inactive status. The committee did discuss better defining the requirements for ethics course to be distance or in person, but staff feels existing definitions set out in 1399-483 subdivision D are sufficient. Additionally, staff does not recommend requiring the course as either Category 1 or Category 2, since this will already occur during the course approval process. Finally, the committee requested adding the words laws related to the acupuncture profession in a division of ethics. Staff feels this is not needed as the continuing education staff conducts analysis and exercises discretion over approval to ensure course content relates to the profession of acupuncture when reviewing course applications. If a continuing education ethics and law course is received that covers law unrelated to health care or acupuncture, then the board has the authority to deny these courses. Per the request of the board, a clarification and definition of inactive status within 1399-489 subdivision C was included by adding pursuant to section 1399.489.1, referencing the definition of inactive status. And then finally, there was a renumbering of section 1399-489 subdivisions to accommodate the addition of subdivision C as described above. And actually, I just wanted to do one clarification in that 1399.483D. Courses concerning law and ethics are specifically called out as Category 1 courses. So I think we can give it to the board for discussion.
Well, that was my
Committee.
first, yeah, thank you. That was helpful. That was going to be my first question, which is why isn't it clear whether it's Category 1 or 2? But it is clear that it is Category 1?
Yeah, well, there's a listing of what would be Category 1 and then a listing of Category 2. But as one of the listings, it specifically calls out courses concerning law and ethics as a Category 1 class. So that's very explicit.
Got it. Got it, good. And so we're not, that's helpful. So it does state it right there. And so we're not requiring it as Category 1 because it is by definition Category 1.
It would be by
Got
definition
it.
Category 1. And if when the analysts saw it, they said, hey, it's Category 1, and they might give feedback to the provider.
Excellent. My only other question was, what's the rationale behind not requiring it if someone's coming off of inactive status?
Well, not off of it. Is it off of an inactive status?
Yeah, so basically, if they're coming back
coming back to
into the
practice?
practice from inactive, we're saying that that requirement is waived. I just don't see why we would want to waive it. I mean, it seems the
I would
opposite.
have to go back and clarify. The way I had heard it, and I may be wrong, is that it was just that when you're inactive, you wouldn't have to fulfill that requirement because you don't have to do continuing education.
To renew on inactive, you wouldn't have to satisfy that
Yeah.
requirement.
I mean, can you
Okay.
But to
clarify
come
his
back to
question?
active, now let me just make sure that,
I just, yeah.
coming back.
I mean, that is a good
probably-
question.
I'm reading
because
it probably.
Coming back to active, it would make sense to be able to provide those.
So when it says renewed in inactive status,
Yeah.
the wording is a little confusing there, but it's very clear language, but saying it is a little hard. Actually, you fixed it.
We
You said
changed it to
on
on,
to
yeah.
take care of that. So renewed on inactive status. So only if they're inactive, then it's waived. And then the other one is if they're renewing their initial license that has been issued for less than 2 years.
Got it. Yeah, I was reading it the opposite, saying if they're trying to renew going
Good.
back onto active. So no, this makes sense. All right.
Oh, phew.
No, it's, I get it. Any questions?
Yeah.
Public comment? Or comments first from staff or
No,
council?
we're
No? Public comment?
Neil Miller, Cal-ATMA, California Acupuncture and Traditional Medical Association. This issue is a huge issue for our association. We've been discussing this. We now have a new ethics committee, and we're mixing our ethics committee with our continuing education academic affairs committee, and we will be writing a course for this. We want to work closely with you to make sure that we're including anything and everything that we could possibly put in there that would meet the board's criteria for being on the proactive, preventative side of this. And we intend to put this course out across the state and offer it many, many times. What we want to know is, do we have to continually, the current statutes, or current regulations say that we have to continually apply for each time we teach the same course? But the new legislation that's going through, if that passes, then that would be, we could just apply once for the 2-year period so that we could teach the course 20 times as opposed to applying to teach this course 20 different times, 20 different locations?
We haven't seen any language affecting that yet. Perhaps that's forthcoming in terms of, you mentioned legislation. There is some legislation that's affecting CE, but we haven't seen the specifics changing any authority as of yet. But are you talking about blanket
As it stands now,
approvals?
if we teach the course 20 times, we have to apply 20 times to teach the same course.
So you
That's
could
correct.
apply, if you know the dates, you can apply for all those dates on one application. But if you have new dates that weren't on the previous course approval, you would have to apply for it again within the proper timeframe.
Okay. We would like to, if that is the rules, then we would like to work with the board and the legislature to make a change. So in the past, the board has not been real proactive at asking for laws to be made or put in statute. And we would like to, that was one of the things that Joint Legislative Review Committee talked about, was working more with the consumers and with the profession. So our association would like to work closely with you and to invite you to perhaps put this as an agenda item and maybe invite someone from Business and Professions Committee here specifically to talk about this issue of ethics. That was one of the big issues that Joint Legislative Review Committee talked about, and this would be handling a bunch of issues. It's the legislators' issue, it's your issue, it's our, as a professional association's issue, wanting to bring up that standard. So please note that we would like to have this on a future agenda item so that we could streamline this process. So that we could say, we want to teach this and instead of applying every time. All right, thank you.
Any other comments?
Might I recommend that the committee make a recommendation on this language?
Can I ask a question first? Just about the number of 4 hours and how kind of that came about or what that's based on.
My understanding is that's based on what other boards require. So it seems to be standard across similar practitioner styles, so chiropractors, psychologists. Psychologists have to do the attestation. There's no requirement. I don't recall the other physician assistants. What was that, the other one we cut, John?
We quoted behavioral science for 6
Optometry.
hours every
There
2
we go.
years. Physical therapy board, 2 hours, and every 2-year renewal cycle. Chiro board, 2 hour every 1-year renewal cycle. So it's very consistent with other healing boards. The other thing is we've been talking about this number since, 1999 or something like that. This has been around for a really long time. I mean, it was referenced in 2012 as 4 hours. So I guess it's sort of the standard that's sort of been across boards.
It's consistent. That's a half day's worth of continuing education.
I guess I want to elicit maybe some conversation or thought on how, why that would also be sufficient for acupuncture profession as applied to acupuncture.
Ron Zeidman from Five Branches University. Yes, this is obviously a very good idea, and it'll be useful for the providers to know what enforcement issues are important. For example, our insurance company every year informs the profession about what insurance cases they've had during the last year. And that information, knowing what's out of balance, helps us then create the appropriate course.
Thank you.
Thank you.
My name is Yongping Chen. This time I represent Cal Education Committee Chair to ask 2 questions. Number one is ethic on-site or online?
For the ethics, it wasn't specific whether it was online or live. It could be offered either way
So either, okay.
for ethics.
Okay. So number 2, will this ethic courses including safety practice?
It will be applicable to your 50 units of renewal, right? It's not
I
in
mean-
addition to.
Like a risk management, a safety practice,
That would be a
Safety.
different domain than ethics and jurisprudence. So this would specifically target the laws regarding your practice,
Okay.
regarding the practice of acupuncture.
Well, it's ethics too.
Laws
So
and ethics, excuse
I
me.
said like safety if the patient in urgent condition and the licensed acupuncture just say, oh, I can treat it, try to make an effort out of the competence. So that's like a risky. So should that be also in ethics?
Is that
Like for some,
comment?
yeah.
If we're venturing a discussion here, I pose to the board members, would the clean needle technique taken every 2 years be something that they would want as opposed to the laws and ethics governing practice? Because clean needle technique would satisfy the safety precautions,
Yeah, that
right?
I understand that.
But there's no laws and ethics being discussed in that, right?
Okay.
I'm just putting that out there as a conversation for the board to have.
Thank you.
Maybe it's also related to incompetency, to understand all the regulations and laws, and also safety for the patients. So you have to maybe it relates to the safety and so incompetency, and also maybe you have to know the system that regulates the acupuncture profession. I think that's more. I don't know. I would say incompetency, because a lot of licensees under, violating the regulation. Sometimes they don't know whether they're violating the regulation or not. So.
Yeah, like some red flag, the patient like heart attack or sweating, some severe conditions.
falls into the incompetency, I think.
Yeah.
Yeah, but
And
you're
also
talking about
about safety. It's a life-threatening condition. Should that include in the ethics? That's my question.
in ethics and risk management. So that, I think that's more.
Risk management.
Yeah, risk management.
Yeah. Should put
Please be
together
mic'd.
or separate.
Okay, thank you.
And also, another point, like the drug-herbal interaction, that can cause a big damage too. So that also, I think maybe can include in the risk management and part of the, maybe could be part of the ethics. Thank you.
Good afternoon. I'm Marilyn Allen from the American Acupuncture Council. We're the ones that tell them what's going on. One of the things I want you to perhaps consider for this, or even later on, is the World Health Organization has established a committee on quality of care and patient safety. Patient safety is the largest issue in healthcare worldwide. And acupuncture and herbal medicines are both going to be included in that classification that's going to be voted on in May. And one of the issues that's probably going to change is people will be able to report adverse events. We've never done that before. This will be a whole new area for acupuncturists to learn about. Plus, we have a lot of insurance audits going on, which are fraud, and there probably needs to be some areas of documentation. It might be interesting for this committee to list some general categories that should be included in the ethics class.
Any other comments? Okay, so we'll bring it back. I think there's a couple things. Council brought up the point about the 4 hours. Can we have a quick discussion about that? I mean, I think that, Mr. Hurt's answer seemed to make sense to me that, the 4 hours is kind of consistent across the care boards. But, it's a good question. I mean, is there any reason to think that acupuncture as a practice should be more, require more or less ethical hours? It's not something that I have considered as a board member or as a member of this committee. So is that something that you guys have discussed internally, and maybe we could just flesh it out a little bit here?
Yeah.
Well, if you don't mind, I
Yeah.
have a few things that I've noticed that I'd maybe like to add. So here, CEs are at 50 hours. It says thereafter, all licensees shall complete 50 hours every 2 years as a condition of renewal on active status. And then it says 5 of those can be Category 2. My understanding is that law and ethics are in Category 1.
Yeah.
So that would mean about 45 hours you can do in Category 1, and you can do the other 5 in Category 2.
Or you can do them all in Category 1.
Yes, you can, but assuming someone does the 45, or even if they do all 50 in Category 1, 4 hours would be, I think, if, I'm not a mathematician, not particularly good at math either, but that looks like about 8.8% of, if someone did 4 hours of the law and ethics, would be about 8.8% of the 45 total. And then going through Category 1, it describes 9 subcategories, and I think that would be about 5%
Right.
of each category would, if split apart evenly, would be about 5% of the 45. So, I mean, what I can say at least, what I'm noticing is that the 4 hours, if that were one of the 9 categories, which it is, it looks like it's B1D, courses concerning law and ethics and health
Right.
facility standards. The 4 hours / 8.8% would be in the ballpark of,
Right.
if you're dividing them evenly, that 5%. So not only is it consistent with other healing arts boards, but divided proportionally, that's I think the breakdown would be in that ballpark.
Well, and you could even think that that proportional part was going to be met with the requirement of the 4 hours. The other ones, you may not meet them all like that one, but we're really saying we want at least that much in laws and ethics, right? The other ones, they could actually choose to wait at one, but we're kind of eliminating that choice for laws and ethics by requiring it, but then setting it in a kind of a reasonable ratio to other pieces.
Uh-huh.
So I think that does make sense.
Exactly, I think as a ratio compared to all the other subcategories individuals can take courses on. So not over-dominating the total 45, but putting it within a reasonable ratio among other courses that they can take. Is that kind of, looks like something I've noticed.
The other thing that jumps out at me, too, when we're looking at the other boards we mentioned, like behavioral sciences, chiropractic, those specifically are situations like acupuncture where people are alone in the room with another client. So the ethical reality is you're not supervised by an institution or anything like that. You're alone by yourself. So the idea of the practitioner having to maintain the ethical standards rather than the institution is something that definitely needs to be considered, right?
Yeah, I think that's helpful. You know, because I do think we, in previous conversations, we as a board wanted to put a priority on the ethics and the law and ethics requirement because of some of the enforcement issues that were coming before us. So I think that discussion was helpful.
And also maybe the disciplinary action, what are they composed of? Like if they violated certain regulation, then we have to put focus more on those who are, we see the more violation. So in terms of just vague ethics, instead of there's those that maybe we can apply into more on the specified categories of in the regulation, those the licenses are violating more.
Right, this came out of, like John was noting, the fact that there was a lot of enforcement violations on unprofessional conduct, right? And this doesn't have to deal with incompetence, that's that's negligence or gross negligence, like we was discussed earlier. So this is a separate category just on unprofessional conduct, sexual misconduct, fraud from the insurance company, improper touching, like all of that is coming down to ethics. It's not coming to proper needling or safety techniques or risk management. This is really about the dynamics between the practitioner and their facility and the individual, the patient.
Yeah. Which kind of pivots into that second question that we heard about, what is going to count? And, there was some ethics and risk management courses. And I mean, I don't know, but have we defined, I guess there is some confusion then about what exactly is an ethics course, maybe, or a law and ethics course. I don't know if that's where these questions are coming from, and I'm not in the field, so I don't know if the practitioners can weigh in. Is it not clear, like, is there not just a law and ethics course or training that is out there?
I think that there's resources available to identify what's ethics and definitely resources for what is law, in terms of that particular clarity.
Okay. One, training programs are required to take medical ethics. Right. So we could look back to the training programs and see what they offer in terms of just medical ethics and what our syllabi of the training programs offer as well.
And the other thing is with CEs, they're done by hours. And remember when I showed you that application, it does hour by hour. And so this 4 hours, we'd want to see 4 hours of laws and ethics. Risk management would be other topics, right? And typically what they'll do with the 4 hours, they would put maybe another 4 hours to give a full days of piece. So you could do the 4 hours of law and ethics, and then maybe you could do the second part of practice management, the second part of risk management, or maybe the board finds the other fields that we want to put in there, what was the other ones? Safety regulations or, emergency procedures or requiring CPR. I mean, it could be endless what we could ask people to do, right, in terms of the specificity.
I guess my concern, and I know for lawyers, we have similar requirements, and they make it very user-friendly. And like, this is a CLE, a continuing, educational requirement that will fit X category, whether it's ethics, whether it's, you name it. And they make it pretty clear, right, for us so that we don't mess it up. I guess my question is it clear to the acupuncturists that they are satisfying laws and ethics by these individual training programs? Because I'm getting a sense that it's not that clear all the time, and that there's some confusion, like maybe something seems like it's hitting on the law and ethics requirement, but it may not, and it may not be clear that it is. Like, how do we define it? How do the educational training programs define it? Like, are there law and ethics, and people can speak to this, I can open it back up, but are there law and ethics classes that are very clearly defined? I just don't know. I mean, I'm totally, I just have no knowledge as to what the answer is, so.
I think with some research you can identify it. I mean, I've definitely done some research at the medical board and seen the CME recommendations, but they have a very robust kind of constantly going on ethics consideration, because they're even getting more invasive in the patient space. People are under anesthesia, there's all kinds of different situations. So there's definitely a big body of knowledge out there around what law and ethics are. But it is the idea, like, what are we exactly speaking about?
Right.
And I think the confusion too is that just even bringing licensees in, the fact that they're having some visiting into the laws, like there's almost a disconnect that with my license, I'm involved with all these laws and regulations. I can speak to that as a former practitioner,
Yeah.
right? So having people to be able to just be reminded of the relationship with the legal system, I think is very, reasonable.
I
The other thing is, as a licensed practitioner who can see patients one-on-one, there is a higher standard for holding ethical behavior. Right? But your question really is, how do we define what that piece is?
Yeah.
I think we could start with the ethics and then try to, it would be great to at least require that piece, right? And you've heard very positive comments from stakeholders along that line. But then further definition would be wonderful if it could be very clearly said, we need X, Y, and Z. Right.
That seems important. I mean, because I don't want someone taking a risk management course and then saying, well, I just took my ethics course. Like that to me should be two different things. So,
Well, we would want to see it if they're doing a CE class in both the objectives and the hour-by-hour schedule, that they were addressing those specific topics. So you can't do a bait and switch kind of a piece, right? It's going to be approved as that. Now, the second part of that would be is if our CE unit was actually going out and verifying that those coursework was delivered, rather than somebody shooting the breeze and going to lunch early or something along that line, right? So there's a lot of moving parts that could be worked with, for sure, that your question speaks to.
I'm just wondering if it makes sense to maybe continue this committee meeting to maybe come back with some of that research so that we can further define it. I do want to approve this language, and so the quicker we get it to the board, the better. But I'm just wondering if we approve this without clearly defining what exactly are we requiring? 4 hours in law and ethics, that's fine. And then if we need to, it seems like we need to more clearly define what that's going to look like.
It would be nice to go slow and get it right.
Yeah, exactly. Yeah, that's a good way of saying it. I'll open it up for you. I'll be nice, even though you already had a comment.
Let's turn that. You're on.
Thank you.
Nope.
Oh, you might have.
Do you want to hand him the microphone?
Here, take my mic.
Neil Miller, Cal Atma. This brings something really close to me. I took a law, ethics, safety class about 3 weeks ago. It was 8 hours. I've been in practice 30 years. So when I heard 4 hours, I was like, oh, great, they're going in the right direction. But now when someone said, why 4 hours, my own thought was, 4 hours isn't enough. And I teach ethics classes at a lot of different schools. I'm really up on the rules. I read the book all the time. So I wonder about all those people who aren't in practice. I learned a whole lot of new things. And another thing that we don't consider and is really weak in our profession is documents. Documenting what it is that you do, what it is that you said, what points you recorded, the depth that you do. It has a lot to do with malpractice. There's an increase lately of pneumothorax. And so this particular teacher teaches orthopedics. It was the Anthony von der Mule course at the Oakland Academy, which was approved for the 8 hours. Opened up a whole new window of the specific issues that I think need to be addressed. And I actually brought to Cal Atma's attention that we want to teach this course. And we were thinking about an 8-hour course that would include these other things like safety. It's not just general safety, but there's certain risk management that has to do with law and ethics. Doing something because it's in your scope of practice, but you don't have the training is unethical. And so there are a lot of things that are in scope of practice that someone might not have the expertise in. They took a weekend course and they feel like they're an expert and they're going to go out there and cause a pneumothorax. And it seems to be happening more and more. So my personal, we haven't discussed it as a board, so other than we want to do a course, we talked about it being 8 hours. My personal opinion is that 4 hours isn't enough. We spent 2 hours on documentation, and I really document well, and I learned a lot in this class, So if I can learn a lot after 30 years doing this, I really think your average person should really up their game, and it would make the enforcement a lot less.
Well, thanks for the comment. And just to, I think that comment again speaks to the confusion about what's going on, because I don't think the documentation piece really fits into the ethical piece. That's my view of this, right? And I think that.
It's another problem area.
Right, it's another problem area, but I think it is separate and apart from what we're talking about here in the ethics realm. But practitioners might see that differently. So I think that, again, this is just an issue I think we need a little bit more clarity on.
Yeah, from my
And we can
experience-
invite the associations to send in any language that they might have or any of their comments. Board members could definitely put something out there, or staff can do some additional research and come back with those to the committee.
Yeah.
From my experience, I think that since the acupuncture profession is kind of new and evolving into all kinds of directions, and sometimes there's not much clear standard. So that's why we have to discuss on whether how we should do it, because obviously there's a regulation is up there, and then we have to be aware of those. So I think that's the point, to be more compatible, competence along with the regulation. I don't know about other health professions. They are well aware of those any regulations to do and not to do, and in sometimes acupuncture profession, sometimes there's no language in there, or sometimes new concept came up and we don't have any regulations. Then so in the sense that we have to be competent with the regulation regulation. I think this can be very helpful for the profession, but at the same time, there's 9 subcategories in category CEU 1. Maybe we can put it as like a you cannot just take one subcategory for 10 years. You have to take at least, including, ethics part, you have to take all in maybe in 2, say, renewal period or something. Yeah. That'll be more balanced.
If I may. Oh, sorry.
Yeah, I'll just make the point, again, I think that's a really good idea, and that's a good discussion. I think I do think it's somewhat related to what we're talking about, but again, separate, because I do think that, again, we're focused on the ethical requirements and the law and ethics because of, again, the many enforcement issues that have come before us that have not been about competency, it's not been about training, it's been about folks just blatantly doing things that were either illegal or totally unethical, right? And so I just don't want to conflate. I think what you were just speaking to is something that we as an education committee should consider as well, which is maybe we should make it to where there are these 9 subcategory or bullet points. We should maybe delineate exactly how many hours should go into each, maybe, right? But I think when it comes to the ethics and the law and ethics piece, we should just be very clear, I think, on what we're talking about. Because I don't think it's a competency issue. I think they are, again, throwing caution to the wind and just doing really unethical and illegal stuff. So they need better training.
This particular issue has made itself known as a specific entity, like you're mentioning. I agree. I think that's an important focus.
And Ben, you were going to say something. I'm sorry.
Thank you. So one thing you were mentioning is it going to be clear to the practitioners that this is an ethics course that they're taking, and it would get rid of the requirement. to institute an ethics requirement, in my mind, I see that we would create the category for ethical CEs, right? So we would be checking when we do audits, we would, on the, let's back it up even more, on the course application, is this an ethics course? We have to treat this differently. We're looking at specific content in an ethics course. The provider would note that it's for the ethics requirement. So it's a whole different category there. If we wanted to do all 9 subcategories of Category 1, that's a lot of mandated specified training. And right now we have 45 of Category 1, 5 possible of Category 2. That's the requirement. And the other one is 25 units max of distance education. So now if we want to move to another level of 9 other subdivisions, or total subdivisions, that's an even more intense auditing process and different categories, again. So that is possible, and it's possible to make it clear if we change other aspects of our process.
Yep.
Additionally, what I was hearing is also echoing your thoughts of Miller's comments, Mr. Miller's comments about an 8-hour program. But in that, there was risk management, in that there was documentation or record keeping. So again, those are other domains, as you've mentioned, and 4 hours of just ethics and jurisprudence, once the proper definition is provided, seems more than enough for that domain. Whereas if providers wanted to offer, hey, on the same day, you can also get 2 hours of record keeping and 2 hours of safety, risk management, then there's nothing stopping that. But the more requirements you add, the more regulations there are going to be, the more scrutiny is going to be required. And I think there needs to be a proper balance between individual responsibility and the board being in everybody's education. Thank you.
I know you've already also spoke. If this is for this item, I'll open it up for, which I didn't do previously, which I should have. I should have taken public comment for items not on the Education Committee agenda. So I'm going to take this comment as that, because you've already commented on this agenda item.
I think the profession is growing up. We have just had our first HIPAA federal violation. They kicked it up from a state level to a federal against someone. And I noticed that in both categories, there's laws and regs, ethics and health facility standards, and then under practice management, it's law and regs unrelated to clinical medicine. So I think I would like to see more specification from you, and even if we go to a third category, since it seems to be required with every other group, and to remind people of the laws and regs, because it's really important. We have more and more. Our company covers insurance audits, HIPAA audits, board things, and we have spent, and each one of them is $30,000 worth of legal fees. And we have paid $30,000 more of legal fees this past year and a half than we've ever paid before, actually more than malpractice claims, because there's so many people that are, and this is nationwide. That isn't just California, but there's so many in California. So I'd really like us to see this pursued.
Defined.
So I have a question.
Yep.
Ethics appears multiple times in the Acupuncture Practice Act regulations for the curriculums of schools. And in none of those instances do I see definition of ethics, I will say. So for consistency purposes, this wouldn't be inconsistent with the way the board's other regulations are written, which is just to say ethics will be required.
Yeah.
So for purposes of, and I think it might help the board better understand, staff's processes, when you're going through curriculums for approval, how do you do that evaluation of what is, if a course satisfies that ethics requirement? Because I'm sure you have many courses listed and you don't go in and detail what is included in that course's curriculum or what would constitute that course. You just have course titles. And one of them also is ethics, law and ethics.
So we would look at the actual, how they're delivering it, and the school would say, I'm going to do it within this course. We'd look at that syllabus, But what we really look at the somehow that they voice that they're meeting our regulation. And so if they said it was including law and regulation, in fact, they would have met that criteria. So there's not a deep analysis into what it all means, right, in terms of that stuff. Because our regulation, we look at, when we're looking at curriculum for the training programs, we look at it pretty prescriptively. We don't get into, what does philosophy mean or something like that, right? Or, something, so. But again, if it's an organic chemistry class, we would look for our organic chemistry elements in that class, right? Because it sort of makes sense with what's going on, right? So, but, yeah, so.
Yeah. Well, so what's most helpful to staff? I mean, what we could do is approve this language as is. I have one potential change, but approve it as is, and then to the extent it's going before the board soon, within that interim period, maybe we can think about how best to define this to the community. I don't know if we necessarily have to define it here. I don't know. I mean, maybe you can approve this language as is, because as council says, it is consistent. I mean, there's not, in everywhere else, we're not defining ethics. But maybe we can then issue guidance as a full board as to what we mean or what education providers should be doing. I mean, is that helpful, or should we as an education committee try to sort all this stuff out before it goes to the full board? I'm happy to do it, again, staff thinks is most helpful. I think that this might linger a really long time if I do the latter, which is keep it here in the committee, have staff do more. I don't want to hold things up either, so.
We could do a dual process. I mean, we can move it forward, and there really isn't resistance for doing it. There's resistance for more clarity, more hours, more this, more that. So
the question is, do we need more clarity here?
Forward. I think just having the discussion is important, and I think important to have the licensees be brought back to the laws and regulations. And the idea of ethics, it's actually is a philosophical idea. You might have a difficult ethics standard than I do. So what is the minimum standard of that? That would be nice for us to know where we draw our line that way, because we love those lines, because we can be clear, right? So some kind of fleshing out of that would be great. And we have heard from our stakeholders that there is definitions of that. Just even today, we don't have very many people, and there are a number of people have tremendous experience. So it seems like that clarity is out there, right? But I do think starting with the boards requiring laws and ethics is an improvement. It does have a public safety ethics. That doesn't discount all the observations that have been brought up. Mm-hmm. And the need for more clarity, more specificity, and all these sub-areas too, right?
Any other thoughts? I mean, is it?
Can I add something?
Yep.
So I think when I looked at some of these other boards that were named in the memo, I don't recall seeing that there was like a definition of ethics even in theirs. Not to say that it could have been somewhere else in their act or in their regulations. But again, like you were saying, with lawyers, the CE providers are putting out there in the advertisement that it's very clear that this relates back to this requirement. So then I'm wondering, does it make more sense for us to make an additional requirement on providers to make that specification that this particular course, once we've approved it, this would satisfy that ethics and laws requirement?
That's kind of what I'm thinking.
On there, as opposed to making a definition. But again, that would be a reg change, so.
Yeah.
It makes it more complete.
Yeah.
It definitely closes the loop.
Yeah,
Lessen the confusion
Right.
for licensees.
Well, and it finishes the process too for the licensee, right? The
Yeah.
provider's being responsible for what they need.
I just think the providers need to be clear from us what they should be providing that satisfies this, so that the users are satisfying it. So yeah.
And the minimum thing we have here is flat. It's 4 hours of law
Yeah.
and ethics, right? And you would have to allow that much CE time to those topics, however those get fleshed out.
So I think my recommendation would be, and Francisco, weigh in whether you don't agree, but I would move this language. I would approve it as is with one small change. I would ask that we just say in that last sentence, because I was confused by it, it would just say, or if the licensee remains on inactive status, right? Because the is renewed on inactive status. Do you renew on inactive status every year? Okay, so.
Every 2 years. If you're staying on it, yeah.
I would just say remains on. I don't know. The renewed on inactive status to me
It gets confusing. 'cause
It gets confusing to me, but, you know, as long as it's clear to you guys, then we don't have to
You're
change it.
renewing your license. One is a renewal of an active status, one is a renewal of inactive status, and the difference is you don't have to do CE units.
Well, also, the renewal points out that that's when the CE is
Got
required,
it.
whereas remaining on it doesn't
Okay.
specify a calendar date.
Got it. Well, if it's clear to you guys, let's keep it. So I'm fine approving the language, and then when we send it, and we can report out on this to the full board, let's just, we'll have some direction that the board, we need to consider what we want to do in making this clear to providers and to users, you know, what is going to satisfy the 4 hours. And we need to figure that out, so,
Yeah, I think it was a great discussion.
what do you think?
I think
Do you need a formal motion? Or, I mean, it seems like it's just direction, right? Or we're just moving it out, so I'll do whatever you guys want, but,
I would say make a formal recommendation. We
Okay.
recommend,
yeah, we recommend to adopt the language as presented in the proposed regulation for continuing education ethics requirement as presented, and would move it to the full board for discussion, noting we asked the board, I guess we asked staff to do a little bit of research on how we can best define and clarify what the law and ethics requirement really is and how we can satisfy it, and that the board should consider that in adopting this, how best to do that, so. Is that clear enough?
that's clear? Francisco?
Yeah.
Are you okay with that?
Yeah.
Okay,
Sorry, that took a little bit longer than I thought it would, but,
that's good.
That was
Thanks.
a really good
It's a
discussion.
discussion.
okay. And I,
Public
sorry, do we
items?
want to do any more public comment on items not on the agenda for committee, or should we not? I mean,
I think that's worthwhile. It's not agendized.
It's not agendized,
Okay.
but you can do it if you like.
okay, just,
Future agenda.
Take public comment.
we'll take public comment on items not on the agenda again, if anyone has anything else to say, before we adjourn this committee meeting.
Neil Miller from Cal ATMA. Yeah, for future agendas, we wanted to talk about the entry-level doctorate, that the committee start to look at the education programs that are out there that are unregulated, and certificates are being given for a lot of different doctoral levels, and there's no standardization between one school and the next. On one school, you could do 2 semesters online. At another school, it's 3 years, 4 years. As I mentioned earlier, the Acupuncture Board had a task force to look at education requirements when the profession was advocating for more hours. And then when we came to a conclusion of 4,000 hours, people protested and said it wasn't about hours, it was about curriculum competency. So we had a year of curriculum competencies committees, and that was about 3,800 hours. So I'd like to ask that that be on the agenda to look at entry-level doctorate. That seems to be the level of education that's necessary in today's world, and there's no standard postgraduate, and the school, the CAB has no say on anything really that happens after graduation. So there's no regulation of any of these committee hours, of these continuing education hours. And the public has no clue. One guy says he's a doctor, and he took 2 semesters online and something else. So I would like to be able to present to the board, and it's a new board, the history of both the education and the curriculum competencies findings, and to open up that discussion. Again, in order to go to the legislature with a little bit of muscle, it's good to have coordination with the CAB. So if the CAB were to feel that this is in the best interest of the consumer, and when I mentioned this earlier, a number of schools mentioned to me at lunch, finally someone's speaking up that we really need to do this. So I'm enthused to know that some of the schools actually feel the same way. Some of the schools have doctoral programs that are really high quality, and they themselves are concerned about lesser quality programs and these abbreviated programs. So we're just looking to have a standardized across the board thing. When the physical therapists moved from just getting a physical therapy license to a doctoral program. They did a similar thing. They made a presentation to their board. Their board agreed with the profession. The board and the profession went to the legislature and said, we need to make some changes. And we would like to see those same substantive changes. So I asked that this be on for a future agenda item. Thank you.
Is CalAtma volunteering to provide a presentation to the board?
Absolutely. We haven't discussed it, but I'm sure that we would feel great about that. And at least to give the historical perspective. And I'll start digging through my files to get those documents.
Thank you.
I'll communicate that. Thank you.
Any other comments?
So I'm Yongping Chen. I'm the Vice President of CalAtma. So Mr. Neil just mentioned that. So I want to just one point. CalAtma, actually, we already adopted a vision for CalAtma to work on. The vision is to 2028. So all the acupuncture practitioners in California should be all doctor degree. So we can recognize by mainstream of healthcare system, by the consumers, public, by other insurance provider. So to offer the consumer the access, fair access of acupuncture provided by licensed acupuncture. Thank you.
Okay. With that, I'll entertain a motion to adjourn.
Sure.
So moved. All right, and I'll second. Great.
Good.
Thanks.
We are adjourned until tomorrow.